please be seated. Now, I think we have Mr. Felstead. Now, Mr. Felstead, could you just give us your full name for the record?
Yes, Barry Felstead.
And do you wish to swear an oath or make an affirmation?
Oh, thank you. I, Barry Felstead, swear by Almighty God that the evidence I shall give to this commission shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Felstead. Please sit down.
Thank you.
Now, Mr. French.
Commissioners, my name is Shepherd. I appear with my learned junior, Mr. French, and I'll be taking Mr. Felstead's evidence in chief.
All right, thank you, Ms. Shepherd.
Mr. Felstead, you've prepared a statement dated the 27th of July 2021 in response to a summons dated the 8th of July 2021. That's correct, isn't it?
That is correct.
And do you have a copy of that statement with you?
Yes, I do.
Is that a document bearing document ID WIT.0011.0001.001.001?
That is correct.
And for the record, that has an annexure A, WIT.0011.001.0069 and schedule WIT.0011.001.0071. Mr. Felstead, is there an amendment that you wish to make to your statement?
Yes, there is, Ms. Shepherd.
And is that an amendment to paragraph 68 of the statement appearing on page 0019?
That is correct.
And what is the amendment that you wish to make?
Thank you. The second line commencing the effect of these clauses, I would like to strike that out, please, and replace it with the following. At all times, I knew there was an obligation of Crown Melbourne in accordance with clause 22.1, brackets RA, 1, 2 and 3 brackets.
And is that the only amendment you wish to make to your statement?
That's correct.
And with that amendment, is your statement true and correct to the best of your information and belief?
Yes, it is.
Commissioner, I tender that statement with its annexure and schedule.
Thank you, Ms. Shepherd. The witness statement of Barry Felstead dated the 27th of July 2021 with the identifier number WIT.0011.0001.0001 will be admitted into evidence as an exhibit. Thank you.
Thank you, Commissioner. I understand that copies have been provided to my learned friends. And before I take my seat, so to speak, I note my learned junior, Mr. French, will be taking objections and I'll be dealing with any re-examination arising.
Thank you, Ms. Shepherd. Mr. Futrell.
May it please the Commission. Mr. Felstead, my name is Michael Futrell. I'm one of the counsel assisting the Commission and I'm going to be asking you some questions. I'm introducing myself because you'll see the room's full of
Yes.
full of lawyers, and just so you know who each person is. Can I just start with that last matter, because I don't know I quite caught the nature of the amendment you've made to paragraph 68 of your statement. Can I just check to see I've got it right? So does that mean the first sentence is, I do not recall ever seeing clauses 22.1 R and RA before preparing this statement? Then the next sentence is, at all times I knew there was an obligation on Crown Melbourne in accordance with clause 22.1 RA, Roman 1, Roman 2 and Roman 3, and that's the end of the paragraph.
That is correct.
Thank you. Now, obviously, with your summons you received a fairly long list of topics or questions, and do I understand your statement to be your full response to each of those topics?
Yes, I do.
What I'd like to do is take you through some of them, perhaps not all of those answers, certainly some where we need some clarification I'd like to see if there's some further assistance you can give the Commission on some of the matters in addition to what you've had to say. So largely it'll deal with the same subject matter, but there may be occasions when we go a little off piece, as it were, into other areas. So if I could just start by getting a full picture of your role within the, I'm going to call it the Crown Group, and by which I mean all the Crown Resorts and all the subsidiaries. You were employed or a director within that group between March 2004 and December 2020, as I understand it, correct?
March, I was an employee. I wasn't a director from March 2004.
I beg your
I
pardon?
wasn't a director from March 2004. I was an employee from March
Yes.
2004.
Your roles changed, but you're within the group for that period.
Yes, I was.
And from March 2013, you were the CEO of what everyone is referring to as Crown Perth.
From March 2013?
Yes.
I was the CEO of Crown Perth.
And as I understand your statement, that included something referred to as the VIP international business, responsibility for that.
That's correct, yes.
And in August 2013, you were appointed as CEO of what is referred to as Australian Resorts.
Yes, that is correct.
And you were in that position, weren't you, until your employment with the group ended?
That is correct.
At the end of last year. Now, as I understand it, again, this is just to make sure we understand the employment structure correctly. Throughout the period of your employment until 2013, your employer was Burswood Resort Management Limited.
That is correct.
And then from 2013, you were employed by Crown Resorts directly, is that right?
Yes, I was.
Okay. Now, in your role as CEO of the Australian Resorts, you had responsibilities for both Crown Perth and Crown Melbourne.
Yes, in addition to Crown Aspinalls as well in London.
I was going to come to that. So there was another casino in London named or known as Aspinalls.
That is correct.
And did it also include, as it came online, the casino in Sydney as well?
That is correct.
Okay. Now, you, in your role as either CEO of Crown Perth or as CEO of Australian Resorts, you held a number of positions as a director of companies within the group.
Yes, I did.
Now, you were appointed to the board of Burswood Limited in 2017. 2007.
Yes, 2007, correct.
And you were also appointed to the board of Burswood Nominees that year.
Yes, I was.
And Riverbank Investments.
Yes, I believe so. Yes, correct.
And a number of other companies within the Perth Casino Group, including Perth Burswood Resort Management.
Yes, that is correct.
All right. Now, I'm going to call up an aid memoir, which I'm not going to ask you to take through every aspect of it. It's just really for the benefit of the commissioners to, which is PCRC.0010.22201, which is an attempt to depict many paragraphs of your statement in a diagrammatic way, which I may return to from time to time to draw your attention to aspects of it to get you to see.
Yes.
Because it may be faster than trying to find the page in the statement. So you'll see what we've effectively been through at this point in time is the the diagram, you have Crown Resorts at the top of at the middle, at the top of the page, and the various company structures that fall under that. Now, you have referred in your statement at paragraph 6 to something you term as Crown Perth, and a number of people have given evidence in this commission. That appears to have been a general description used to describe the group of companies that fell under Burswood Limited.
Yes, that'd be correct. I'd refer to that as a catch-all.
As a catch-all?
As a catch-all. So I regarded myself as working for Crown Perth.
Yes.
Obviously, I was employed by Burswood Management Resort, and we had the various other structures. But in terms of simplicity, I regard myself as working for Crown Perth.
All right. Now, that was in your role as CEO of Crown Perth?
That's correct.
And the ultimate holding company of that group is Crown Resorts, obviously?
Yes, it is, yes.
And so do I take it from the answer, from the way in which you've just sort of answered those questions, that within the Crown Group itself, Crown Perth was considered a single business unit?
Yes, it was considered a single business unit.
And was in that regard, was the management structure for which you were responsible essentially dealt with in the same way as a single unit? So
yes, typically that would be correct.
Yes. So did it have, in that context, did it have a budget of its own as a unit, a business unit?
Yes, it did.
And did it report its financial results to the group as a single unit?
Yes, it did, as a single unit.
And were financial targets set by that division as a single unit as well?
That is correct.
All right. Now, in your role as CEO of Crown Perth, you reported to the most senior, executive of Crown Resorts, whether that was at the time the Chief Executive Officer or the Executive Chair. Is that correct?
That is correct.
So in 2020, that person was Mr. Barton.
Yes, that's correct.
And he was CEO and Managing Director of Crown Resorts at that time.
Yes, that's my recollection.
And from 2016 to 2020, it was Mr. Alexander.
Yes, that would be correct.
And he was Executive Chair at that time.
Yes, that was his role.
And from 2013 to 2016, it was Mr. Craigie.
That is correct, yes.
And he was the CEO and Managing Director of Crown Resorts.
That's correct, yes.
At the time of your appointment as CEO of Crown Perth, was the business unit then known as Burswood Entertainment Complex?
Yes, when I was first employed by Burswood Resort Management, it was called Burswood Entertainment Complex.
And at what point in time was it rebranded or renamed Crown Perth, approximately?
My recollection, that was in or around 2012.
All right. Now, I just want to ask you, in the period before 2013, who did you report to at that time?
Prior to 2013, I reported to Mr. Craigie.
In what position was Mr. Craigie at that time?
Mr. Craigie was then, my recollection of that was he was still head of the entire property. So he was CEO of Melbourne, Perth, but I think his role from memory was, I think it was CEO Crown Limited or Crown Resorts. I can't quite recall, but he was the overall head of the business.
I see. So I want to ask you some questions about the nomenclature around Australian resorts and what that meant. So in August 2013, you were appointed as the CEO of Australian Resorts.
That is correct.
And do I understand from your evidence that was an amalgamation of the positions of CEO, Crown Perth and Crown Melbourne?
Yes, it was.
And was Australian Resorts itself also a single business unit within the Crown Group?
No, it was not a single business unit.
So it was, this time in two separate units, was it? It was the Crown Perth Group and the Crown Melbourne Group.
That is correct.
I see. And so the chief executive of each of those properties reported to you as the CEO of Australian Resorts. Is that the reporting lines?
No, that's incorrect. What occurred back then was I was the CEO effectively, title aside, I was effectively the CEO of Crown Perth, the CEO of Crown Melbourne, and the operating heads of the business units in Crown Melbourne and Crown Perth reported through to me. So there was no particular CEO of Crown Perth or Crown Melbourne when I was CEO of Australian Resorts.
Okay, so the title of the people reporting to you was Chief Operating Officer of each of those properties.
By and large, yes.
See, now, in your statement, you've referenced that from, I think, October 2016, you assumed operational oversight of what you refer to as VIP International.
That is correct.
And is the timing of that because Mr. O'Connor was detained in China?
Yes.
And am I right in thinking that the expression VIP International is interchangeable with International Commission Business?
Yes, it's one and the same.
It's the business that the Crown Group ran, whereby international patrons were attracted to come to Australia to gamble in one of the casinos operated by Crown Group.
That is correct.
And that business, whatever title you place on it, consisted of junket operations, in part.
Yes, it did.
And that involved junket representatives, in part.
Yes, it did.
And premium, something I think referred to as premium players.
Yes, that is correct.
And they are all from outside the Australian jurisdiction.
Yes, typically, yes.
And so was there something also known as a privileged player?
No, that was not a term that we used, privileged player.
Right. So is the difference between a junket and a premium player a question of who has the contractual arrangement with Crown?
Well, in both instances, the players either a premium player or a junket operator had a contractual arrangement with Crown. The best way to characterise that would be a junket was a person who was controlling a group of players, and a premium player was someone who would come down solely on their own play.
I see. Now, in your statement, you've mentioned that from 2016, the International Commission business, with the exception of hosting and on-ground servicing of customers, was run out of Melbourne.
Yes, that is correct.
And is it the case that the International Commission business was a separate business unit within the Crown Group?
Yes, it would be a separate business unit, along with many others, but yes, definitely.
So it operated separately, did it, from the operations of each of the geographic locations as its own unit?
Sorry, could you please just rephrase that?
The International Commission business, I think you said, was its own business unit?
Correct, yes.
And so did it, for example, in the same way that we've been through with Crown Perth, have its own budget, reporting and financial targets?
Oh, yes. Yes, it did.
Sorry to interrupt, Mr. Futrell, but it would assist me if some time period was put on this, because as I understand it, Mr. Felsted's statement sort of identifies different management obligations in respect of ICB at different points of time.
Thank you, Commissioner. I'm coming to. I may have overlooked that. I'm here referring to the period after 2016.
Yes.
And was the international commission business at that time regarded as part of the Australian Resorts business unit or group?
It was more regarded as part of Crown Melbourne that would provide a service to Crown Perth. So it was based in Melbourne, the key management were based in Melbourne, and it operated like that.
Okay. And before, I want to come back to this probably at a different point in time. So before 2016, what was the position with regard to Crown Perth and the operation of the International Commission business?
Yes, from recollection, prior to 2016, Crown Perth had a very small management team who were running the business. When I say running it, they were servicing the business in Perth, but the majority of the, the international sales support was all coming out of Melbourne.
All right, I will come back to the structure of that particular business unit in a moment. But before I do, can I just ask you some questions about the periods during which you were employed by Burswood Resort Management and then later Crown Resorts. So if I could begin with the period from 2007 to 2013. In that period, your employer was Crown Resorts Management.
Yes, it was.
And did you have a contract of employment with that company?
Yes, I did.
And was there a document that set out a description of your duties and functions?
From memory, there would have been. I don't particularly recall it now, but there would have been a document. It would have possibly been in my contract.
Okay. And was there a process by which performance targets were set for your personal performance each year?
Yes, there was.
And who was involved in the establishment of those targets?
That would be Mr. Craigie. So Mr. Craigie would establish my targets and review me on such.
And was there any involvement in that process by any members of the board of Burswood Limited?
Not that I can recall directly.
And in that period, were you entitled to any incentives associated with your remuneration?
Yes, I was.
And what were they?
From memory, in that period, I would have been eligible for a short-term incentive, which was based on the yearly performance of the company. And I also believe I was a participant in the LTI, the long-term incentive, which was more a group-based incentive.
I see. And were those incentives connected to the financial performance of Crown Perth?
The short-term incentive was connected to the financial performance of Crown Perth. The long-term incentive was connected to the overall performance of Crown Resorts.
And in that period, was the performance of the International Commission business that went to Perth regarded as part of the financial performance of Crown Perth?
Yes, it was.
And for the long-term incentive, that's to say that the group as a whole, that collected and picked up Crown Melbourne, Aspinalls and any other locations, did it?
From recollection, yes.
Now, in that period, if you did you have, to your recollection, any document by which you were given an authority to conduct the affairs of Crown Perth?
No, short of my employment contract.
I see. And did you understand there to be any limits on the extent of your authority to transact business on behalf of Crown Perth at that time?
Yes, there would have been limits on what I could sign, for example. There would have been limits on what decisions I could make, but it was generally, I was in charge of the property, reporting through to Mr. Craigie, and the limits in terms of what I could and couldn't do were generally outlined in my contract.
I see. And so if you reached the point where you needed to obtain authority from someone else to transact some business you wish to do, who did you go to obtain that authority?
From recollection, my first port of call would have been Mr. Craigie.
And at that time, Mr. Craigie was the CEO of Crown Resorts, correct?
Recollection, yes.
Now, I'm going to ask you the same series of questions, really, in respect of your period, the period when you were CEO of Australian Resorts. In that period, you were employed by Crown Resorts directly. In that period, so this is from, I think, 2013 onwards.
Yes.
Did you have a formal contract?
Yes, I did.
And again, did you have a document that set out the description of your duties and functions?
From memory, it would have been broadly outlined in my contract.
And again, was there a process by which performance was set in each year?
That is correct.
And again, with whom did you deal when you were setting your targets for each year?
Typically, that would be with Mr. Craigie.
And I think in that period, you became entitled to some executive incentives.
From memory, yes, I did. I became entitled to a LTI, a long-term incentive.
And the details of those incentives are recorded in the annual reports of Crown Resorts, are they not?
Yes, that is correct.
All right. Now, in that period again, now in respect of your function as the CEO of Crown Perth, were there any, to your knowledge, documents that delegated any authority to you for the purposes of transacting business on behalf of Crown Perth?
No, I don't recall that.
And so again, if you needed in that period to obtain authority from anyone where it exceeded you understood under your contract, your employment contract, who did you see? Who did you ask for authority?
Typically, that would be Mr. Craigie.
And after Mr. Craigie had resigned?
Then it would have been Mr. Alexander.
And after him?
After him, it would have been Mr. Barton.
So in each instance, if you required authority to do something you did not think you had, the first person you sought authority from was the most senior executive of Crown Resorts.
That's correct, in their capacity as my direct manager.
And is it the case that the person who gave you your direct instructions or directions in so far as you need them to manage Crown Perth was also either Mr. Craigie, Mr. Alexander or Mr. Barton?
It would have been those gentlemen in combination with the board.
All right. Now, insofar as you had a role in the oversight of the VIP international business, was there any separate document identifying what your role and function was for that business unit?
Sorry, could you repeat that question, please?
So far as you had a role in the oversight of the VIP international business, was there a separate document to that of your employment contract as CEO of Australian Resorts that identified what your role and duties was in respect of that business unit?
From recollection, no.
In respect of the management of that unit, from whom did you take your instruction and direction? when required?
The management of the international business, if there were things that I needed escalated, I would typically escalate that to Mr. Craigie or Mr. Johnson on occasions.
And Mr. Johnson at that time was a director of Crown Resorts, correct?
Correct.
And he was also a director of one of Crown Resorts' major shareholders.
That is correct.
But he was not in an executive role within the Crown Group, was he?
No, he wasn't. No, I probably would qualify my previous answer and say that was more an advisory role that I would, as opposed to an authoritative role.
I see. So you sought Mr. Johnson's advice, but not his direction. Is that the substance of what you've said?
That would be a good way to characterise it.
All right. Now, after Mr. Craigie had left the business, do I understand it to have then been Mr. Alexander?
That is correct, yes.
And after him, Mr. Barton,
That's correct again.
to the extent there was any international business going on in 2020.
Yep.
Oh, all right. Now, after you were appointed as CEO of Australian Resorts, where did you reside?
Yes, good question. I spent time between Perth and Melbourne. My family residence was in Perth. I had a permanent room in one of the hotels in Melbourne.
And what about your place of work effectively? Did you have an office in Melbourne?
Yes, I did.
And did you retain an office in Perth as well?
Yes, I did.
And just in broad terms, what degree of your management time was spent in Melbourne and what degree was spent in Perth?
Physical time in Melbourne, I would say roughly probably 70 to 75% of my time would have been spent in Melbourne on the ground.
And in terms of managing that business, is the magnitude or the proportion roughly the same?
Probably no, I wouldn't characterise it as that. I would have, I spent a lot of time managing Perth or assisting to manage Perth remotely by various electronic means, but in physical time on the ground, I definitely spent far more time in Melbourne from 2013 on.
All right. Now, at the times that you were, and I appreciate this is going back into the annals of time somewhat for you, Mr. Felstead, but when you were appointed as a director of Burswood Limited, Burswood Nominees and Burswood Resort Management, I gained the impression from your statement that effectively you considered to be an office that went with your job as CEO of Crown Perth.
That is correct.
And do you recall the way in which you were appointed as a director?
No, I don't have a specific recollection of that.
Do you recall how you became aware you were to be a director of those companies?
I would have... Look, I don't have a specific recollection of that. All I can assume is that it was an historical practice that when you were the CEO of one of the entities, you became on those boards. Now, who asked me to go on that, I don't recall, but typically that's how that would work.
All right. Now, can I ask you another question? And this relates to, I want to go back to some questions I asked you earlier. You remember I went through a series of questions in relation to who you reported to and who you took instructions from when you were just the CEO of Crown Perth.
Yes.
Who you took, again, when you were Australian Resorts and for the VIP international business. In any of those management functions, at any of those management times, when you needed authority to deal with the Crown Perth site, were there any occasions when you sought authority from any other structure within the Crown Group, a person or structure?
Not that I can recall. Typically, my first I guess my first reference would have been Mr. Craigie, but there would have been times I would imagine, or I can assume, that I would have had instructions or advice from one of the various boards.
When you say one of the various boards, are you referring there to one of the Crown Perth boards or the Crown Resort structure above Crown Perth boards?
It would have been either.
Either. So, insofar as the Crown Perth structure goes, is the effect of your evidence that your recollection is that there were occasions when you sought authority from either Burswood nominees or Burswood Resort Management or Burswood Limited?
Yes, there would have been occasion on that. I would have done that.
All right. Now, insofar as Burswood nominees and Burswood Resort Management goes, those were companies of which you were a director and another executive of Crown Resorts director. That's correct, isn't it?
It is correct.
So, in fairness to you, when you were seeking authority, presumably you weren't seeking authority from yourself. So, are you referring really to Burswood Limited?
Yeah. Yes, I would have been referring to Burswood Limited because the board was a board of Burswood Limited as opposed to Crown Perth or Burswood nominees. So the board that met on a quarterly basis was Burswood Limited.
And are you able to recall the nature of any decisions or any authority you sought from the Burswood Limited board as opposed to those where you sought authority from Mr. Craig or Mr. Alexander or Mr. Barton?
There would have been instances in relation to in around capital expenditure or projects that we may have thought was something was desirable. That would have been typically the board would give feedback on that, and then that would either get ratified in a way by that board, then escalated through to the resorts board for further discussion, sign-off, approval, and the like.
In your observation, your experience, which of the boards, Crown Resorts or Burswood Limited, was the final decision maker on those capital expenditure decisions?
That would have been Crown Resorts.
And so, just to get a sense of how it worked in practice, a practical way, in your experience or observation, was the board of Burswood Limited used as like a sounding board to, if you like, sanity test for, in a West Australian context, the strategy of Crown Resorts?
The strategy of Crown Resorts in relation to its Perth position, I think that would be a very good characterisation of that.
And so there was an element of influence, but ultimately the final decision laid with the Crown Resorts Board.
Yes, that would be correct.
You were, as you can see from this memo, Mr. Phil said, you wore a lot of hats. Appreciate that. And one of the hats you wore was to sit as a member of the Executive Risk Compliance Committee. I think I've got that right, which is the ERCC.
That's correct.
And can you explain to the Commissioners your understanding of what the function of that body was?
Yes, the function of that body was risk would be managed, risk would be identified and reported through the various business units. That would end up with ultimately that would end up with the Executive Risk and Compliance Committee in Perth. That was a series of that committee consisted of a series of senior managers of Crown Perth, including myself. That was chaired by Mr. Preston. Such issues would be discussed, debated, and from that particular committee, the minutes or a version of that would go on to papers for the Burswood Limited Board, which would be titled Legal Risk and Compliance.
And do you know of your own knowledge how that paper that was developed for the Burswood Limited Board was prepared? Was it you the author or someone else?
I know I wasn't the author. I would read it before it would go out. That would typically be prepared by Mr. Preston and or his team, and I would read it before it would go to the Perth Limited Board.
I see. And was it your remit or your responsibility to prepare the CEO's report for that board?
Yes, yes.
And who looked after the financial information?
The financial information would come from the CFO of Crown Perth at the time, and later the CFO of Australian Resorts at the time.
All right. Now, I think I could be wrong about this, Mr. Felstead, so if I am, just correct me. I think you also sat by invitation fairly regularly on the Crown Resorts Risk Management Committee.
Yes, from about, I think it was from, I can't remember the period, but I did sit on that I was an invitee to that.
And is it the case that the ERCC in Perth reported in effect to the Crown Resorts Risk Management Committee?
Yes.
So, to understand again in a practical sense how the business was operated, the ERCC was reporting to the Burswood Limited Board on the risk management activities of Crown Perth.
Yes, it was.
And there was a way in which it also reported to the parent company's risk management committee through your invitations, or was there some documentation prepared and sent as well?
Yes, there was documentation prepared, and it was a similar thing for both Melbourne and for Perth. Risk documentation, a version of the ERCC committees in both properties, would be prepared and formalised and sent to the Crown Resorts Risk Committee and discussed.
All right. Now, did you participate at all in the meetings of Crown Resorts?
I was an invitee. I wasn't a member of the board. I was an invitee to the Crown Resorts board meetings from roughly about the time I took up the position of CEO of Australian Resorts.
All right. Now, do you know, as of your own knowledge, the extent to which the Crown Resorts Risk Management Committee was, to use your terminology, escalating matters of risk management in connection with the Perth Casino to the Board of Crown Resorts?
Yes, my recollection at the time was the chair of the Crown Resorts Risk Committee would give an update to the Crown Resorts Board at each meeting, and any issues of note would be discussed, debated, and dealt with there, if need be.
All right. Now, I just want to ask this in a general sense. When one is dealing with risk, and you recall in the questions you were asked, there's a reference to risk appetite. The process you've just described, whereby matters of risk are referred ultimately to Crown Resorts Board, would you agree with me that that's the opportunity or the point at which the executives of the company receive some indication from the board of the appetite for risk?
Yes, I would agree with that.
So when something is escalated to the governing body in dealing with a matter of risk, and the executive has said, this is the risk, this is how we propose to control it, if the control is one that is unacceptable for the board, the executive would receive that information.
Yes, typically that would be correct.
And so if a matter relating to risk is not escalated to the governing body doesn't have the opportunity then to provide that indication to the executive of the risk appetite.
Yes, that would be correct.
Now, insofar as your observations are concerned, and if you are unable to answer this because you are not sufficiently familiar with the dealings of Crown Resorts, then please say so. Insofar as the escalation of risk associated with Crown Perth was concerned, in your experience and observation, was essentially the same information being provided to Crown Resorts as was provided to Burswood Limited?
Yes, I would say that would be correct.
And in your observation, in terms of...
Sorry to interrupt. Can I just clarify that?
Yes.
There was more detail provided to the to the Burswood Limited Board in the papers, and the information that would go to the Crown Resorts Board would be probably more truncated.
In your observation and experience, were there any instances where, for example, something was escalated to the Burswood Limited Board and you received one response on risk appetite, and the same information is escalated to the Crown Resorts Board and you receive a different indication on risk appetite?
No, I can't recall that.
I'd like to, you recall this, well, the documents aren't yet available, I don't think, Mr. Felsteed, for there's been some communication, I think you're probably aware, between your solicitor and the solicitor assisting the Commission regarding some propositions.
Was that coming out of the Bergen inquiry?
Yes.
Oh, yes.
Sorry, I've been a bit oblique. I'll come back to those when we can put them up on the screen. But before, just as a general matter, a general proposition, I'm going to put something to you. You don't agree with it, of course. You can rephrase it to the extent you are happy to agree with it. But would you agree with the proposition that casinos, this is casinos in general, that offer, they offer gambling for entertainment, and they also undertake various financial functions that are similar to financial institutions?
Oh, sorry, was that a...
Yes,
Oh, sorry.
It's a long question.
No, I understood that. No, yes, that is correct. I would agree with that.
And from your quite extensive experience in the casino industry, you understand, do you not, that the operation of a casino is vulnerable to criminal infiltration?
Yes, I do understand that.
And I think, if I understand your view correctly, you would regard controls of the risk of, for example, some form of criminal infiltration as an important part of the management of a casino.
Yes, I would.
And at the time that you were the CEO of Crown Perth, you understood that it specifically was vulnerable to criminal infiltration.
Yes, as a casino, it was definitely vulnerable to criminal infiltration.
And did you at that time appreciate or enter your viewpoint that if criminals were permitted to infiltrate the Perth casino, it had the potential to undermine public trust and confidence in the integrity and credibility of the licensee, Burswood nominees?
Yeah, most definitely.
Now, again, via your quite lengthy experience in the casino industry, did you understand that the ingenuity, if you like, of the criminal community has no boundaries?
I was certainly aware of that.
And therefore, the the ways in which a casino may be vulnerable to criminal infiltration are many and varied. Correct?
Oh, yes, yes.
And so the licensee really has to be quite vigilant in terms of the controls to keep up with the criminals.
I would agree with that.
Now, there are, again, I'm going to put some general things to you because if you're going to be in the casino business, you are quite clearly going to be exposed to that risk of criminal infiltration. Correct?
Correct.
And so it's a price of doing business in that industry effectively.
Yes, it's certainly a factor in doing business.
Now, there are, again, you can feel free to disagree with this proposition if you wish. There are ways in which you can conduct your business that are either more risky or less risky when it comes to the vulnerability to criminal infiltration.
Yes, I would agree with that proposition.
And there are aspects of the business that you may wish to conduct that are also higher risk to criminal infiltration. I'll give you an example, which is junkets. Would you agree that junket operations brings with it a higher risk of criminal infiltration than a normal patron walking in off the street?
Yes, I would agree with that.
And would you agree then with the proposition that if one wishes to conduct, as a casino licensee, junket operations, then one has to have in place adequate controls to meet that increased risk?
Yes, I would agree with that.
Can I come back now to ask you some questions? I want to refer you to paragraph 85 of your statement to really unpack what appears to be quite a lot of information in there, Mr. Felstead. And this return to one of the questions Mr. Commissioner Jenkins asked earlier about the time frames. It's not completely clear to me what's before and what's after 2016 in this paragraph. So can I start with towards the end of the paragraph, you say from 2016 the ICB, with the exception of hosting and on-the-ground service of customers, was run out of Melbourne.
That is correct.
So do I understand that to mean that if we are thinking of ICB before 2016, it was at least in part run out of Perth?
Yes, that would be a good way to describe it.
All right. Now, in that period, and I appreciate that junkets were run at Perth for quite a long time, but if there is a sliding changes or whatever, you can just identify it by reference to each period, but at least prior to 2016, who within the Crown Perth structure was the person responsible for that aspect of the business?
From memory, that was a gentleman by the name of Neil de Lima.
And what was his job description or job title?
I don't recall a specific title. It would have been along the lines of Vice President, International Operations Perth, something along those lines, something with the word President and Vice in it, more than likely.
All right. Now, the Burswood Entertainment Complex was a standalone business before it was acquired and ultimately taken over by Crown Resorts, correct?
Yes, it was.
So was this structure you've just described, the individual in question, his position, a legacy from a pre-takeover period, or was it something which developed after the takeover?
It was a legacy position, Mr. Futrell, to a degree. prior to Crown, if I can just add a bit of colour, that may help.
Please
Prior
do.
to PBL back then, coming in 2004, the Burswood International Resort Casino, which it was, I think that was the name of the property back then, had a large standalone international operation. It was actually the largest international operation in Australia in terms of business. So they got a lot of business, a lot of junkets, a lot of premium players. They had their own credit team, they had their own sales team, they had their own management team. As and when PBL came in, part of the sales team moved over to more a Crown sort of group, and there were parts of the business which remained. So I think the way you expressed it before was correct. There was just a little bit of colour about how that worked.
Okay, there was quite a lot of information in that answer, Mr. Phil said. You spoke quite quickly. I hope the transcribers picked it all,
Apologies for that.
up. And I don't know I caught all of the dates in there, but if I just summarise what I think you said, and you can fix it if it's wrong. Am I right in thinking that in the period prior to the takeover, there was a standalone junket operation in Perth of some significance for the Perth casino operations?
Correct.
And that would have been, I take it, in a period before 2010?
That was before 2004. I was talking pre-PBL and post-PBL.
Okay, so let's break that up into time frames. So before 2004, a substantial standalone business in the international attraction of international customers.
It was a very large business, correct.
Takeover 2004 or thereabouts. What, if anything, then happened between 2004 and 2016 to the nature in which that business was operated?
There was no direct sales team that was employed by Crown Perth or Burswood back in those days. That moved, but there was still a management function for international operations in Crown Perth, and there was still an administrative function for international operations in Crown Perth.
All right. So, does that mean that prior to whenever the change occurred, Crown Perth had its own sales team for junket operations?
Yes, it did. It had a sales team and offices, international offices as well.
I see. So did it have a sales team and international offices in presumably somewhere largely in Asia?
That's correct.
And the changes that were brought about later resulted in the sales team moving into the orbit of Crown Melbourne. Is that right?
Yes, the orbit of Crown Melbourne / and they were responsible for both properties, but it was more centred around Crown Melbourne.
And in your observation, was the consequence of that a diminishment of the amount of business that was arriving in Perth?
No, it wasn't a diminishment. That wasn't the cause for the diminishment. What actually occurred over time was that the Perth business, it started back in the mid-80s. It was a very, very strong business. They had enormous amounts of international volumes. Over time, that diluted as other casinos came on board. And by the time, memory serves me correct here, from the time that we came in about 2004, 2005, the business was a fraction of what it used to be.
I see. So this is my term, but you can adopt it if you wish. There was a degree of rationalisation taking place with respect to the Crown Perth international business in the period post-takeover.
Yes.
All right, now I want to ask you some questions about some expressions you've used in this paragraph, which I don't completely understand. You've used the expression hosting. What does hosting mean?
Hosting would mean when a player or a premium player or a junket arrives on property, we generally would assign a host to that particular player, depending on the size and magnitude of the player or the junket.
So is a host an individual who is directly managing or is the direct point of contact between Crown Perth and the junket operator?
They would be the direct point of contact for things non-financial. So it would be, an example would be a premium player comes over from Malaysia, for example. They're a big player. We would assign a host to that particular player. They would take them shopping and the like. It was more a pure hosting role.
All right, and who had responsibility for the management of the hosts in Crown Perth?
So are we talking pre-2016?
My apologies. Let's start with pre-2016 and we'll deal with post.
There was a dedicated team in Perth that would do that.
And who managed them?
That was under the ultimate control of Mr. Neil de Lima.
All right. Now, was there any extent to which there could be, I'm going to use the expression cross-pollination, meaning people with a financial role, Cage, AML, credit, finance, would be involved in the hosting of international customers?
No, not that I can recall.
Was there, to your knowledge, any prohibition on that within the Perth Casino operating procedures?
I don't recall that. I'm not aware of that.
Well, what I mean to say is, was there any point at which, for example, a member of the Cage staff could come into contact with directly, in a hosting way, with a junket operator?
No, nothing really springs to mind in relation to that. I think it would generally be in their role from a cage transactional perspective, as opposed to a hosting role.
Well, again, was there any prohibition on that? Because, for example, if someone worked in the Cage, could they also be involved in meeting and greeting patrons at the airport, for example?
I don't recall. I'm not aware that would typically happen.
All right. Now, in the position after 2016, was it any different to what you've just described?
No, not to my recollection.
So was the same individual involved in the management of the hosting component of the business after 2016? Mr. Delaney? Is it?
No, Mr. de Lima left the business
De
around
Lima?
2016 from memory, and then the hosting was still, there were hosts still based in Perth, but they were reporting through to someone in Melbourne.
So a person in Melbourne then managed the hosting service, if I could call it that, in Perth. Is that correct?
Yes, that's correct.
And who was that person?
That was Jacinta Maguire.
Right. Okay. Now, again, you've used another expression here I'd like to know a bit more about, which is on-the-ground servicing of customers. Is that distinguished from hosting, or is it part of the same exercise?
That was essentially hosting.
I see. So this compendious phrase, hosting on-the-ground servicing of customers, is the same role, is it?
Yes, it
Same
is.
function. Okay.
Mr. Futrell, could I just clarify something? You said that the international business in Perth was at one stage one of the largest in Australia, but it then went into decline, and it was, the word you used, it was a fraction of its former self. Was that, had that decline occurred before 2004?
Yes, Commissioner. My understanding it was a decline. I think it hit its peak in the late 80s from memory, and I'm going on memory here from things that I've been made aware of, and it was declining after that with other casinos coming online, especially in the region of Asia.
Thank you.
Thank you.
All right. Now, again, you may have already answered this, but I'm not sure that you have. So, forgive me if I'm repeating the subject matter. In paragraph 84 of your statement, you've mentioned that there was, I take this to be a post-2016 period, but probably in general terms a pre-2016 period as well, the general description of junket and premium players. The part of that paragraph I'm interested in is with the lion's share of the business going to Melbourne. Are you able to explain to the commissioners your view on why the lion's share of the business was going to Melbourne?
Yes, Melbourne was always seen by our customers as a far more attractive destination. For a variety of reasons. It may be it was a large urban property. It was certainly bigger than Crown Perth. Melbourne was seen as a physical location to be far more desirable for international customers, and there were far more direct flights from the various Asian hubs into Melbourne.
And so in terms of the overall offering, if you could put that way, the Crown Group to international customers, what was your perception of the Perth Casino's place in that function?
Perth Casino's place in that function was, I could probably describe it as Melbourne was seen as an urban experience. Perth was seen as a more resort type experience.
And so in terms of marketing Crown Resorts or the Crown experience overseas, what was your understanding of the attractiveness or attributes that the Perth Casino added to the overall package?
Yes, Perth Casino would be pitched, as I said, as a resort-style property. We would get a lot of people who would want to come here and play golf, for example. We would get a lot of the customers that would come here who we actually purchased a large boat, so customers want to go on that. We had other facilities. Perth never had the restaurants, it never had the shopping experience. That was always a downside for us, but we tried to pitch Perth as a more, call it a fun destination for customers in terms of doing things outdoor. So customers might go to Margaret River, they might go, like I said, they might go on our boat, they might do helicopter trips to Rottnest Island and the like. So it was more an outdoor experience versus Melbourne, which was more of an urban shopping type dining experience. Apologies for the long-winded answer on that.
No, that's. Thank you for your answer. Now, you've mentioned also a gentleman by the name of Michael Chen in paragraph 85. Now, that is a reference to Mr. Chen, who was the Executive Vice President of International Marketing, China and Macau region, correct?
Mr. Chen ran the entire sales team, so that was his role, including that obviously, but his role was to run the entire sales team.
His position, as I understand it, was an overseas position. It's like he was physically located in Asia.
Yes, he was. He resided in Hong Kong.
And again, now we're now in the period pre-2016.
Yes.
Mr. Chen reported to Mr. O'Connor.
Yes, he did.
And Mr. O'Connor reported to you.
Yes, he did.
And you've referred, I think, to sales staff reporting to Mr. Chen. They are sales staff, I take it, who were also located outside Australia.
That is correct.
So, insofar as you know what I mean when I say the China arrest matter goes, the sales staff of Crown who were arrested or detained in China were part of Mr. Chen's sales team.
Yes, they were.
Would that be a convenient
Yes.
time?
We'll come back at 11:25. We'll break to 11:25. Thank you.
Thank you.
All rise. All rise.
Please be seated. Thank you, Mr. Felstead.
Thank you.
Mr. Futrell.
May it please the Commission. Mr. Felstead, just to return to the subject matter of the international commission business and in particular its operations in China. I want to understand, if I may, that in the period before 2016, were there any independent junket operations that came just to the Perth casino via the ICB business?
From recollection, we had, I think there may have been possibly one or two who would be utilise Perth that would not go to Melbourne. That's a memory.
I see. So, just to understand it in general terms, in the context of the Lions share going to Melbourne, is it the case that, by and large, when a junket tour was organised, it would certainly go to Melbourne and it may come to Perth?
That would be a fair characterisation.
And there may also have been some specific junket operators who had a separate or a desire only to visit Perth, but I think your evidence is that would be a few.
Yes, maybe that would be a small number.
All right. So in that framework, then that's pre-2016 as well, and we could put a time frame on it for a period leading up to 2016. Is that right?
That's correct. Yes.
And you might recall you've given a statement. You gave a statement to the Bergen inquiry that was in fact used in another proceeding, I think, where you've described a period as the relevant period being from 6 February 2015 to 14 October 2016.
Yes, I do remember giving that as a period.
Yes, which I think was the area of interest for that statement and the Bergen inquiry because that period dealt with period during which information was becoming available as to the what I might call a crackdown in China on gambling in Macau.
Yes, that period was certainly in relation to information coming to head.
So in terms of what we just dealt with as to the division of junket operations and the manner in which they were organised, would that would apply to that period, the 2015-2016 period?
Yes, the 2015-2016 period they were still getting junket business.
Perth directly
And Melbourne. Perth on a much lesser scale.
I don't want to confuse you, Mr. Felsley. So I think the substance of what you had to say was that most business went to Melbourne. If it went to some junkets also came to Perth if they were going to Melbourne.
Correct.
And there was a few that came directly to Perth in general terms.
That's correct as well.
And just to be clear, that was the state of play, if you like, in the period before 2016 and in particular 2015-2016.
That would be correct.
Now, within Crown Perth, perhaps I should start by saying, as the CEO of Australian Resorts and receiving direct reports from Mr. O'Connor, I take it you were familiar with the way in which the international commission business was operated, both in Australia and in China.
Yes, I had a good working knowledge of the business.
Were there any other members of the executive in Perth who had the same level of understanding of the operations in China and Melbourne and Perth?
Mr. Bossy would have had a knowledge of the operation in Perth, not probably to my degree.
All right. Would Mr. Bossy, to your knowledge, have had an understanding of the way in which the junkets were marketed in China and in that period?
I would say no.
Would others in the Perth office have had an understanding of the information that Crown Resorts, I'll say broadly speaking, was receiving from different sources about the crackdown in China on gambling?
I don't believe so.
So would it be fair to say that, and I take it this is due to your role as the CEO of Australian Resorts, you were, insofar as Crown Perth is concerned, the person who had the most information available to them about what was happening on the ground in China in that period?
Yes, that would be fair.
Can I ask you? I want to ask you a series of propositions, and it's based, Mr. Felstead, on me having read quite a bit of your evidence in Bergen, the Bergen inquiry, and you can obviously feel free to disagree with these or qualify and explain how you would like. I just want to get a sense of whether you accept these things, and in part, partly they're based on conclusions that the Commissioner reached in the Bergen inquiry themselves. So, and I'm going to use the expression relevant period each time, and each time I'm using it in the same sense in which you used it in your statement in the Bergen, which is that 2015-2016 period.
Yes.
So the first is that you knew at that time or understood that the legal system in China was and is different to the legal system in Australia.
Yes, I did.
The second is that you knew and understood that China is a country where the law may be enforced inconsistently.
Yes, I was aware of that.
Third, you knew or understood that there is a risk in China of Chinese authorities taking arbitrary action.
Yes, I was aware of that.
And you knew or understood that China was a riskier place for Crown staff to be working than working in Australia.
Yes.
Now, again, in that relevant period, you knew or understood that and now I'm specifically referring to Crown staff marketing in China, were being urged by Mr. Chen to continue to make greater sales on behalf of Crown and the ICB business.
Yes.
All right. Now, of those 5 things we've just been through, to your knowledge, who other than yourself within the Crown Group structure had that information available to them?
Mr. O'Connor. Members of the VIP working group, which would have included Mr. Johnson, would have been aware of those factors. Mr. Craigie would have been aware of that some of those factors in a broad sense. I think the propositions about China being a riskier place to do business, some of the earlier propositions you made, I think that would have been broadly understood by the boards. That's probably all I can recall at this point in time.
Okay, now, were these matters that, to your knowledge, were brought to the attention of the members of the ERCC in Crown Perth?
Not that I can recall.
And what about the Crown Resorts Risk Management Committee?
No, not that I can recall.
And what of the? And I'm going to refer here to the when I say the directors of Burswood Limited, I really mean the independent, non-Crown executive members. What about those individuals?
No, not in a specific sense.
All right. Now, can I ask you? Unfortunately, I don't know that this document has been loaded onto the system, so I'm going to have to put some things to you. All right, now, again, I'm going to. Have we got the LTS? We have. Sorry, I think it might be simpler to do this, if I may, by reference to the document, and give you an opportunity to read it, Mr. Felsteed. The first thing is, are you aware of some correspondence that's passed between your solicitors and the solicitors assisting the Commission?
Yes, I am.
And were you given a copy of it and read it to before it was sent?
Was this the information in relation to the Bergen inquiry?
Yes.
Yes, I was.
All right. So if I could, what's the reference? PCRC. .0002.0017.001.
0012, I think, Mr. Future. Oh, right. So now 0001.
Now, could I ask that the operator, first of all, Mr. Felstead, have you been provided with a copy of this letter before today?
I had a copy of this letter, but I don't have it on me now.
That's okay. Can I just ask you to just, if the operator could scroll to the schedule of responses to propositions. And I want to draw your attention at this time to, there are a number under the heading Arrest of Crown Staff in Mainland China, beginning at 7. It may be, Mr. Felsteed, that if I could just give you an opportunity to read the propositions 7 through to 28 in your own time, and I'll ask you some questions about them.
If the operator could scroll up, please. Yes, if the operator could scroll up, please. The next one, please. Next one, please. And the next one, please. Next one, please. Yes, I read those, Mr. Futrell.
Right, thank you, Mr. Felstead. Now, you'll see that some of them are disputed, but I want to just focus on those that are not, if I may.
Certainly.
So if you look at the first in number 12, which is, I'm paraphrasing here, is an understanding that there was a crackdown in China in the relevant period. And again, here we're talking about that 2015 and 2016 period. You accepted that you knew of that at the time?
Yes, I do.
And 21, which is to deal with the reports of the employees of South Korean casinos having been arrested in mainland China. You're aware of that?
Yes, I was.
And you're aware that was in connection with the crackdown that was happening in China at the time? That's a separate question, Mr.
Yes, yeah, I was aware in relation to South Korea that that was a separate issue. They were doing things that they shouldn't have been doing as opposed to a general crackdown.
Right, but you're aware that employees of a casino from South Korea had been arrested in June, around June 2015?
Yes, mate. Yes, I was.
And you're aware of in 22 that you'd received an email in June 2015 about being on high alert?
Yes, I was aware of that.
And you were also aware in July 2015 that some staff had been questioned by Chinese police?
I was aware of that.
Now, taking those matters into account and the risks that I took you through earlier, Mr. Felstead, would you accept that urging Crown staff to continue to make greater sales in the face of knowledge of questioning of staff in China by Chinese authorities, the arrest of the South Korean casino employees, and a crackdown on foreign casinos in China, that it exposed Crown staff to an unacceptable risk of detainment or for questioning or worse by Chinese authorities at the time?
My response to that, Mr. Future, would be that in relation to the things that were going on in China at the moment, we certainly took measures, which I believe at the time were adequate, in relation to ensuring that what we were doing was firstly legal, and what we were doing certainly was also not going to put the staff at risk. That would be my response to that.
I want to focus not so much on whether it was as a matter of law in China, legal or illegal, but really having regard to the factors that we addressed earlier concerning the inconsistent application of law in China and the arbitrary nature in which Chinese authorities can act. That having regard to the information that was available to you at that time, it must have been clear to you there was a considerable risk to Chinese staff in China that they would be detained by Chinese authorities.
My view of the business that the staff were doing in China was there was always an element of risk in doing business in China. Were particular time frames, it was a more heightened risk. I think there were certainly periods around that where it was more heightened. But generally, I was satisfied that the measures we had in place were adequate to look after the staff, and hence my frequent visits to China.
And what were the measures that you had in place to, as you term it, look after the staff?
There are probably two key things. One, we received regular advice from WilmerHale, which is a large law firm over in China, about what we were doing was legal. That was probably the first one, and the answer was yes, with certain restrictions on that. The second component was we also engaged a company, a government advice company, headed up by the ex-CIA chief in China, called Mince, who were giving us advice as well. They gave us particular advice in relation to South Korea. There are also numerous other international casinos operating staff in China. Some of them are operating offices in China. So from my perspective, and it was a combination of those factors that probably gave me a degree of comfort that we were not breaching Chinese law and we were being sensitive to what was going on in the ground at the time.
Mr. Felsen, I appreciate your answer. That largely what you've described as measures, though, were, as I understand your answer, the receipt of information about, if you like, what the nature of the risk was. What, if anything, was being done to mitigate the risk to the staff in China that they were being exposed to by continuing to sell and market Crown Casino in China at the time?
Well, I don't want to repeat myself, and I won't, but it does really come back to what the staff were doing in China. So we had a set of protocols. The staff were informed to keep a low-key approach, which was in line with the advice we were getting. We were advised not to do, we didn't do offices over there. So it was never an overt presence in China.
Now, is it the case that you, I think I'm right in saying the evidence you've given is that if you like, the nature of the elements we've described, the risk, was not a matter that was escalated to the Crown Resorts Board at the time?
That's correct. I acknowledge that in my submissions. In my conversations, in my evidence in the Bergen inquiry.
Yes, that's where I think I've read it. So when it comes to your discussions with Mr. Craigie, for example, he was the relevant executive at the time. I think it was Mr. Craigie.
That's correct. Yes.
Were these matters that you had discussions with him about, or you thought were of a sufficiently serious risk nature that you should discuss them with Mr. Craigie?
No. As I indicated in the Bergen inquiry, I did not discuss that with Mr. Craigie, and that was something I should have done.
And within the unit itself, this is the VIP International unit, were there discussions around the management of the risk?
Within the VIP unit, there definitely was discussions around the management of the risk.
And did those discussions go any more broadly than the VIP International Group itself? In other words, to the Chief Operating Officer of either Crown Melbourne or Crown Perth?
No, I don't recall. I don't believe so.
Now, in the end, the staff who were arrested in China were ultimately, many of them, I think, were convicted of offences against Chinese law, were they not?
Yes, it was, from memory, it was gambling. That's what they were convicted of.
And this, that effectively was the same legal law about which you had received some advice from your external advisors.
My recollection was the advice we were receiving was in relation to a specific statute of the law. I think it was statute, I think it was 303 from memory. Don't quote me on that, please. I think it was that, which stated how you could deal with customers in China, as in meeting with a certain number of people, not receiving a commission or kickback. I wasn't aware of, I don't believe that the staff in China were charged with that. I believe they were just charged with the overall crime of gambling.
I see. Now, is it your understanding that under the law of China at the time, there were some laws that prohibited gambling?
I would have had a general knowledge of that, yes.
And was it your understanding that those laws prohibited gambling both in China and outside China by Chinese citizens?
My understanding at the time would have been that it was illegal to gamble in China.
And did you understand that the effective nature of the crackdown of the Chinese authorities was to attempt to prevent Chinese citizens from gambling outside China?
My thrust of the interpretation of that was in relation to primarily government officials and certain high-profile people and politically exposed people in China, gambling, particularly in Macau. That was probably the main thing I took from that.
And was it your understanding that crackdown in relation to the government officials and PEPs by reference to a concern of the Chinese government about money laundering?
My understanding at the time, Mr. Futrell, was it was more in relation to corruption.
Well, let's consider that for a moment. So if an official is corrupt and they wish to dispose of their ill-gotten gains, as it were, one way they may do that is by laundering it through a casino, correct?
That is correct.
So it is reasonable to assume, is it not, that one of the concerns that the Chinese government may have had concern the laundering of corrupt money?
Yes, that may well be.
Now, is it your understanding, was it your understanding at the time, and now I'm talking about the relevant period yet again, that there were also laws of China and other countries, but China in particular, that restricted the amount of currency that could be removed from China?
Yes, I was aware of that.
And did that remain your understanding until you left your employment with the Crown Group?
Yes, it did.
Now, would you accept that any patron of a Crown casino that removes from China more than the permitted amount of currency in order to gamble in a casino in Australia would be exposed to prosecution by Chinese authorities for breaches of their home country's laws?
I would regard that as a logical conclusion.
Is it the case then that the VIP international business, at least to some extent, was founded on exposing Chinese nationals to breaching Chinese law by removing additional for more than their permitted amount of currency?
No, I wouldn't characterise it quite as that. I don't think it's as defined as that.
All right. Well, the Chinese national could have an amount of money in a bank account in Hong Kong, for example, that may not be subject to the restrictions on foreign currency. But if the Chinese person wishing to gamble in Australia had their funds located in China and they want to take more than the allocated amount out of China, they would need to breach Chinese law, would they not?
Yeah, I think as a simple premise, that would be correct.
So would you agree with the proposition that the VIP international business has the effect of, or had the effect of, encouraging Chinese nationals to breach the foreign currency exchange laws of China?
I would still say that would not be the key thrust of it, Mr. Futrell.
All right. Now, you'll understand what I mean when I refer to the China UnionPay card.
Yes, I do.
And you understand that to have been a system for a payment system involving China UnionPay that was utilised at Crown Melbourne.
Yes, I do.
And is it your understanding that one of the advantages to patrons from China of utilising the CUP card was that it could be used to obtain cash for gambling purposes at the Crown Casino in Melbourne?
My understanding of the China UnionPay process in Melbourne, it was used for the purchase of goods, as in chips, and not cash directly.
All right. Well, the system, was it your understanding the system worked essentially in this way? A patron with a CUP card would present it at the hotel for payment of something recorded as a room charge.
I think it may be recorded as a cage transaction. I found that out subsequently, but at the time I wasn't aware of that.
All right. But it was presented at the hotel?
That's my understanding, yes.
So the Chinese patron's credit card account receipt would refer to a payment to Crown Hotel, not Crown Casino.
I'm not sure in relation to that. I don't know the answer to that one.
All right. Leaving aside what the record of the transaction was on the patron's account, the effect of the transaction was that cash would be released at the cage in the Crown Casino in Melbourne.
What was released at the cage with chips it was actually a thing called a chip purchase voucher, and that would be converted into chips for play on the tables, obviously.
All right. So whether it resulted in the intermediate step of cash being credited to the patron's account with Crown Melbourne, the ultimate effect is the card was presented for payment at the hotel and the patron received chips for gambling or tokens for gambling in the casino.
That's correct.
Now, you understood at this period, did you not, that a similar practice was adopted by other casinos?
Yes, that was my understanding.
And did you also understand that a similar practice was utilised in Macau involving shops in the vicinity of the casinos in Macau?
Yes, I was aware of a similar process, not quite like that, but it was a similar process that was occurring in shops in the casinos in Macau, in the actual casino itself.
Yes, and you understood, didn't you, that the practice in Macau was thought to violate Chinese anti-money laundering laws?
I don't think I had a opinion on that at the time, or a view on that at the time. I knew it existed. I knew what they were doing, but I don't think I turned my mind to the legality or illegality of it.
Do you recall receiving some information from within your VIP International group about media reports to that effect?
No, I don't have a recollection of that.
All right, can I ask that we call up CWN.548.010.0692 and CRW.900.001.0033. Place them side by side, and then on the second one, operator, please scroll down a bit. Perhaps if you just read the email, Mr. Felstead, and the attachment.
Yeah, next page, please. Yep, next page, please. Thank you.
Mr. Felstead, has that assisted your memory at all regarding the state of your knowledge in the relevant period regarding reports of the Chinese authorities' views of the use of the CUP card in Macau?
No, not specifically.
All right. Now, do you recall having discussions with other Crown executives concerning the introduction of the CUP card to Crown Perth?
Yes, I do.
And what do you recall of the nature of the proposal to introduce it for use in Western Australia?
My memory serves correct. There was a request from the international team to have a similar China UnionPay facility in Perth that was in Melbourne. I don't recall particularly what time that was or what year or around when that was, but there was definitely a request to have China UnionPay accessible to patrons in Perth as it was in Melbourne.
Now, the rules in Perth regarding the use of credit cards by international patrons to obtain gaming chips were different to those in Melbourne, were they not?
I believe so.
And the introduction of the CUP card into Western Australia, was that intended to involve the same process that we dealt with earlier concerning Melbourne, that is to say, presentation at the hotel in exchange for chips or tokens at the cage?
No, I'm not sure the mechanics how it was going to work. It was more a conversation around, can we use China UnionPay in Perth? I wouldn't have got involved in the mechanics of it.
Was it your understanding that there needed to be an amendment or any amendment to the Western Australian regulatory framework to bring about Crown Perth's use of the CUP card?
No, I don't recall that. I do recall that Mr. Preston was going to raise it with the regulator. That's my memory of that.
And did you have any, to your recollection, have any follow-up discussions with Mr. Preston about his interactions with the regulator?
No, not that I can recall.
Did you understand whether or not Mr. Preston was of the view that the then existing casino manual would have, in its terms, facilitated the use of CUP at that time?
No, no, I don't recall that.
You got the reference for that one? Letter was attached to Boss's letter to us. Can I call CR? Is that the attachment or the letter? On the attachment. All right. It's okay. Just call it CRW.701.004.3552. Can you please scroll, operator, to there's an attachment to that, which is a letter of 1 April 2016 to the GWC. Now, Mr. Felstead, can I just ask you to look at this letter? It has a contact of, sorry, keep scrolling.
Is this the one dated July 21?
No, it should be dated 1 April 2016. It's another attachment.
Okay.
To that letter. This is not the relevant one. Operator, can you scroll it down? You haven't found it? It's always better when we had paper. Perhaps we can come back to that. Okay, now, just dealing with this, can I ask you this? Was your understanding regarding the use of the CUP card that it was a card that, in effect, patrons of the Crown casinos wanted to be able to utilise with Crown Melbourne and Crown Perth?
Yes, broadly, yes.
And the reason, your understanding of the reason that they wished to use it was it provided them with the ability to disguise that they were using their credit to acquire gaming chips from Chinese officials.
No, that was not my perception or interpretation of that.
You didn't understand that the purchase of using a credit card in a hotel in order to obtain gaming chips in a casino was not considered desirable by the Chinese patrons because it allowed them to, if they wished, to demonstrate a different nature of the transaction?
No, that was not my understanding.
What was your understanding of your Chinese patrons' desire to utilise the CUP card in your casinos at that time?
My understanding of the Chinese patrons' desire to use the card was it was typically used as a top-up when, say, for example, a player might bring X amount of funds over. They may lose those funds. They may look for a top-up. They would use the card for that. My understanding of the China UnionPay from all along was it was also a debit card. I wasn't aware of a credit facility on that. I thought it was a debit facility. And I regarded the card using the card at Crown to purchase chips is similar to a Chinese customer coming to Australia or a Chinese tourist coming to Australia and purchasing a large a Rolex watch or an item of jewellery are regarded as a similar transaction.
Why then the intricate nature of the transaction? Why not simply present the card at the cage?
At the time, I wasn't aware, but I did become aware later that it was there was a limit on you couldn't do credit. Sorry, you couldn't do a withdrawal within 50 metres of the casino. So that was the rationale. I found out later behind that.
Now, it wasn't in fact introduced in Perth, was it, the CUP?
No, I don't believe so.
Who, to your knowledge, within the Crown Perth group was involved in discussions relating to the introduction of the CUP card in Perth?
From recollection, it was primarily Mr. Preston, myself to a degree, and that would be, I can't recall others who would have been involved in that.
Is it something you think that the Chief Operating Officer of Crown Perth may have been made aware of?
I don't recall. I would assume, and this is an assumption only, that he would have been made aware of it. He may have had a view, but I don't recall having discussions with Mr. Bossy about that.
And what about the General Manager of Cage?
Oh, apologies, yes. The General Manager of Cage, I would expect to, he would have been made aware of that.
And at the time, who was the General Manager of Cage?
That was Mr. David Brown.
Okay, and what about was there a department in Crown Perth at the time known as the Finance Department?
Yes, there was.
And what was their function?
Their function was they would do the monthly accounts. They would do. They would look at the banking statements. They would process. I believe they would process card transactions. So yes, they may well have been involved in that as well.
And was there also another department known as credit?
There was a not from 2016 on, Mr. Future. That was run from Melbourne, but prior to that, there was a credit department there.
And what was the nature of their function?
The nature of their function prior to 2016 was to they would make recommendations on credit for overseas customers through a variety of mechanisms. They would look at credit worthiness, other casinos, limits and the like.
Were they exercising the same function with respect to domestic customers in that period?
Not from a credit perspective, but from a cheque cashing facility perspective, yes.
All right, I want to come back to the cheque cashing facility because I've got some questions for you on how that works. It's not entirely clear from the manual. But, all right, so now you've said, I think in answer to my question, Mr. Philistine, a number of times, would have, I think you used the expression would have. Do I understand from that you don't have a clear recollection of who specifically was involved with the exception of Mr. Brown?
That would be a accurate characterisation.
All right. Now, at the time, who would have been the lead person of the finance department in that period prior to 2016?
In Crown, that would have been...
Crown Perth.
Crown Perth, that would have been... I think would have been Vasula Kessel.
All right. And who did Vasula Kessel report to?
From memory, Vasula reported through to Mr. McGregor, Mr. Alan McGregor.
And Mr. McGregor occupied the position of CFO of Crown Perth at the time, did he?
No, Mr. McGregor occupied the role of CFO of Australian Resorts.
I see. Was there a CFO specific, this is 2016, was there a CFO specifically attached to the Crown Perth group?
No, there was not.
And so the person exercising all of the accounting and finance function at that time for Perth was this lady you've mentioned, Vasula
Kessel.
Kessel. Okay, and who then at that time was leading, up to 2016, that is, the credit group in Perth?
I think I indicated there was no one leading the credit group. The credit group is run, up until 2016?
Yes.
All right. We had a lady by the name of Heather Ryan who was there for a period of time, but she would work in conjunction with Melbourne in relation to credit. So she was more an admin role on the ground in Perth.
All right. Now, just in terms of the credit in Perth, the Department in Perth's function, was part of their function up to 2016 to consider the creditworthiness of junket operators who were going to operate junkets in Perth?
Yes, but it was more, I'm not trying to confuse you here, Mr. Futrell, it was more, that information was mostly coming out of Melbourne. The role of this person in Perth was more an admin role type. So a lot of the credit decisions back then were getting made out of Melbourne.
All right. This is before 2016?
This is before 2016.
And after 2016, did it change?
After 2016, there was no credit control operative on the ground in Perth.
Do I understand that to mean there was not a person in Perth who was making decisions with respect to the credit of patrons after 2016?
That is my recollection.
And does that apply both to the international commission business and to the cheque cashing facility described earlier?
Definitely the international business. I'm not certain on the local cheque cashing facility. My assumption would be that would be the case.
All right. Now, can I ask you some more questions in connection with the international commission business? Now, again, I'm going to ask you some general questions because I know you have a vast experience in running casinos in Australia. Am I right in thinking that you understood, really up to the point you left the Crown Group, that overseas patrons, some overseas patrons at least, use people referred to as money remitters or money changers as a means of depositing funds into Crown Casino accounts?
Yes, I was aware of that.
And one of the reasons that patrons are attracted to using money remitters is it's a means of bringing about foreign exchange, bringing in exchanging currency in their home country for Australian dollars in Australia.
Yes, typically at a favourable rate.
At a favourable rate. And you understood, did you not, that it was a mechanism of bringing about that exchange that did not involve any currency moving across the border, if I could put it that way? Perhaps I could go back one step.
No, I think I understand what you're getting at. Yeah.
And the answer is?
Yes.
So was it your understanding that the way in which a money change operated is that the patron would see their money change in their home country, provide their home country's currency to their money changer? You're nodding?
Yes, so far, I'm with you.
And then the money changer would make whatever arrangements the money changer wanted to make with their contacts in Australia, and the patron would receive credit to the value of the foreign currency in Australia in Australian dollars.
Yes, that would roughly be my recollection of that.
Now, did you also understand at that time there to be a known association between money changers or money remitters and organised crime?
I didn't turn my mind to that, no.
whether you turn your mind to it or not, did you understand there to be a connection? As in, let's just say that the services offered by money changers were known to be utilised from time to time by organised criminals.
I think, yes, from time to time, that may have been the case.
But it was your understanding when you were the Chief Executive Officer of Australian Resorts, correct?
My understanding when I was Chief Executive Officer of Australian Resorts was that there may have been occasions where a patron was using a money changer for reasons as you described.
What I'm getting at, Mr. Felser, is the patron could be completely innocent in the exercise. It may be that the money changer it has an arrangement with an organised criminal, so the funds that are used in Australia, for example, come from a illegitimate source.
That may well be the case.
And you understood that to be a risk associated with the utilisation of money changing services.
Yes, that would be a risk.
So you understood at the time that one of the risks to which broadly speaking, the casino operation was exposed was that patrons utilising the services of money changers may have involved, through the money changer, money laundering.
Yes.
Now, I understand, again, as a general proposition, I understand this to be the effect of some of the evidence you've given previously. So again, you can feel free to disagree with me on this. Do I understand your evidence or your understanding of perhaps I should ask this first. I'm now referring to the Riverbank Investments bank accounts. And do I understand from your evidence in the Bergen inquiry, your view to be that the practice of a casino operating an account that does not bear the name of the casino or mention casinos in it was common?
Yes.
In your experience in the casino industry?
Yes.
And do I understand it to have been your evidence it was common because some patrons wanted to maintain, you use the term privacy when it comes to the purpose for which the funds were to be ultimately used?
That is correct.
And and do I then understand that Timmy understands, you understood at the time that you were director of Riverbank Investments and the other companies within the Crown Perth group, that the Riverbank Investments accounts existed?
Yes, I did.
And you understood that they were being used by patrons to deposit funds used for gaming at the Perth Casino?
Yes, and or repayment of debts.
And or repayment of debts. And you understood that the reason that the name of the company was Riverbank, in quotes, Investments, was so that your patrons would be afforded that level of privacy, is that right?
I was probably more focused on the word riverbank as opposed to the words investment. So I never assumed that it was to disguise the fact they're making a bogus investment, for want of a better word. It was just more the privacy element.
Well, whatever the name, it doesn't mention casino, it doesn't mention Crown.
Certainly doesn't.
And you understood the reason for that to be so that the patrons, effectively, when the patrons showed their account to a third party, you wouldn't reveal the funds were being used for gaming.
That's correct.
Now, would you accept that then that by operating an account in that way, Riverbank Investments was facilitating its patrons to mislead third parties into the use to which the funds were ultimately to be put?
I certainly didn't. I didn't think of that at the time, but what you're saying is correct.
You may not have thought at the time, but that is in reality the purpose for which the account was established, is it not?
The account was established for the deposit of funds, as we spoke about, and it was established to give patrons, in my view, a degree of privacy.
But wouldn't you agree with me that really the word privacy is a euphemism, is it not? The privacy is the real reason is to prevent the patron from having to disclose to a third party the purpose for which the funds are being used.
I don't agree with. I don't disagree with that premise, but all I can say is that was never the intent, to my knowledge, of casinos, and I'll use many casinos in this, operating accounts under a different name. But I certainly appreciate the fact you're making that that was the unintended consequence of it.
Mr. Felseed, I'm not trying to suggest to you that it's right or wrong one way or the other. I'm just trying to understand what the rationale for the existence of the account was. So is it the case that, and this is probably not confined, I accept, to the Crown Group itself, if there was a common practice of utilising accounts of this nature, that it was effectively seen as offering a service to the patron of the Crown Group?
Correct.
So if all of your competitors, in your mind, were offering the same service, to be competitive, you would need to offer it yourself.
I wouldn't have thought of it like that. My thoughts around this was it was industry practice and Crown followed.
Now, am I right in thinking that the Riverbank Investments accounts and the operation in the way we've just dealt with was a service that went hand in glove with the international commission business?
The operation of the accounts was certainly important for the VIP business because that was how they would deposit funds to redeem outstanding debt or for front money.
Yes, what I'm really asking, Mr. Felseed, is I just want to understand, was the Riverbank Investments account and the common practice we have been traversing something that you understood to be a service that was desired by local patrons as much as international?
Yes, I would agree with that.
So is the case, is it that your understanding was that local patrons would equally want, in your terms, to have the ability to, the privacy, to have the privacy in terms of the use of the funds?
Yes, that would be my understanding.
To your knowledge, who else in the Crown Perth group knew of the existence and operation of the Riverbank Investments accounts?
Sorry, can we just be particular as to what time period?
Yes, sorry. In the period up to the closure of the account in 2019, so between, say, 2014 and 2019.
That would have been Mr. Preston, Mr. Bossy, the finance team, the cage team. Just trying to think who else would deal with the bank accounts. Obviously Treasury, which was a group role, they set up the account, but that was not a Crown Perth business unit. they're probably the ones that spring to mind. I'm
All
sure
right.
there are others I've missed, but
All right,
that's-
can I try and maybe assist you with
Please.
some titles that might assist my understanding? So I think you mentioned Mr. Preston.
yes,
Do I take it that's in his role or as part of the AML team?
that's correct.
And so who else within the AML team in Crown Perth would have had the knowledge of the existence and operation of the accounts?
Oh, I can't say definitively, but I would make an assumption that, no, I don't want to do that. I think members of the AML team generally, I can't think of any names at the moment, would have known about the accounts.
How many members of the AML team were there at the time? Since 2019?
Oh, in 2019, I think in Perth, it was a group function. I think in Perth there were 2 or 3 on the ground, but I'm not 100% certain about that.
All right, can I just ask for, just to clarify this, prior to, say, for a period of time, say 5 years prior to 2014, or the period during which you were the CEO of Crown Perth, is the position any different in that period? So in other words, were there differences between when you became CEO of Crown Perth and 2014 and the period after 2014 until 2019?
Oh, that's a very hard one for me to answer. I can't really recall back that far, but I would imagine going back to pre-2014, it would be a similar group of people who would have known about the Riverbank account.
All right. So we have the AML team. I think you mentioned, I may be putting words in your mouth, but I think you mentioned the cage.
Yes, the cage definitely would have known about the accounts.
And I think we've already established that Mr. Brown was the general manager of the cage in Perth at the time.
That's correct, yes,
So I expect he would have had knowledge of these matters.
definitely.
Were there other people in a management role who had some responsibility for the oversight and operation of those accounts other than Mr. Brown?
There would have been the finance team in Perth, which I think I might have mentioned. They would have been looking at the accounts. There would have been, I think, pre-2016, the VIP international team that were there, primarily Mr. De Lima, would have known about the accounts.
So finance, the team was headed up by Ms. Kessel.
Yes, she was I think, Director of Finance or Financial Control. I can't recall the exact title.
All right. And what about credit control?
Credit Control would have known about it when they were there in the position, but obviously after, I think it was 2016, that position no longer existed, but they would have known about it, yes.
All right. And you mentioned Treasury as well, I think. Is that a group function?
Treasury is a group function, and the role of Treasury managed the accounts. So Treasury, if you think of it like this, Treasury was the owner of the accounts. They had negotiations with the bank. They set up the accounts, and they would do all negotiations with the bank.
All right. Now, who are the signatories on the account, to your knowledge?
No, I don't know the answer to that.
You were a signatory, were you not, as a director of the company?
I may have been.
All right. Now, I think, again, I'm going to put a proposition to you, Mr. Felstein, which I think is derived from reading some of your evidence elsewhere, which is that there were a similar set of accounts operated in Crown Melbourne by a company called South Bank Investments.
That's correct.
And under the regulatory regime in Victoria, the existence and operation of the South Bank Investments account required the approval of the regulator in Victoria. Correct?
That is my understanding.
Yes. Your understanding is that the existence and operation of the Riverbank Investments accounts did not require approval of the GWC. I'm referring here to the Gaming and Wagering Commission, correct?
Yes, I was made aware of that.
Were you made aware of that At what point were you made aware of that?
I was made aware of that. I believe it was around the time of the Bergen inquiry. I didn't really have any input, involvement with the bank accounts, the setting up or the operation of the accounts. That was done by a different area. But I was aware, obviously, as media allegations came about and the Bergen inquiry got going, I was aware of issues around that particular account.
All right. Was it your understanding, and tell me when, if you had this understanding, it first arose, that the GWC were informed of the existence of the Riverbank Investments accounts?
That is my understanding.
And is it when did you acquire that understanding?
I can't recall specifically. It was later down the track. I think it was when the accounts were getting more public and more of I was more informed of things then.
Now, as the CEO of Crown Perth, you understood that the casino accounts were provided to the GWC? Bank statements were provided to the GWC from time to time?
No, I don't recall that.
Did you understand at any time that bank statements of Riverbank Investments were provided to the GWC?
No, I don't recall that.
To your knowledge, at any time, and I mean at any time in the period that you were the CEO of Crown Perth or the CEO of Australian Resorts, was the GWC informed of the purpose for which the Riverbank Investments accounts were opened?
No, I don't recall that.
After the, let's say, in the period from the middle of 2019 when you'd be aware there were some public allegations about the operation of those accounts. After that, to your knowledge, was the GWC informed of the reason for the existence of the Riverbank Investments accounts? And by the reason, I mean this issue of providing privacy.
No, I don't have a recollection of that.
Did it occur to you in that period after the middle of 2019 that providing full and frank disclosure to the GWC about the nature of that account was something the licensee should do?
Yes, I think that would have been a desirable thing to do.
And it wasn't, to your knowledge, done?
Not that I'm aware of.
Has it been done at any time up until the point in time you left the Crown Group, to your knowledge?
No, I don't recall that occurring.
Can I ask you to have regard to your witness statement and paragraph 138 of it? You were asked here, you might recall one of the topics, you were asked some questions about the Riverbank accounts.
Yes.
And in 138 you make reference to them being closed at least at one point in time by HSBC because it was your understanding was it was exiting the gaming business.
Yes, that's correct.
What was your understanding of the reason for HSBC exiting the gaming business?
My understanding at the time was HSBC, this is what I was informed at the time, did not want to do business with casinos. I'm not sure why, but it was a position, and I think from memory, it was a position they took in relation to any gaming institution.
Do you recall if it may have had something to do with the way in which casinos operated accounts in connection with the gaming operations?
No, I don't recall that.
Now, you've referred in the next paragraph to the closure of the ANZ Riverbank Investments accounts in 2014.
Yes, in 139.
Yes. Now, you knew at the time, did you not, that the ANZ closed them over concerns relating to money laundering?
No, I wasn't. I wasn't aware. I wasn't informed it was specifically in relation to money laundering. I was just aware the accounts had been shut.
Who made you aware that the accounts had been shut, to your recollection?
No, I don't recall that.
Is it the case that your evidence is you were informed by someone that the ANZ accounts had been closed?
Yes, I do. I do recall being informed of that at some point in time.
And did you ask the question why?
No, I don't believe I did.
I'm going to ask you whether I'm going to put something to you that is somewhat hypothetical, Mr. Felsteed, but on the assumption that not only you but other members of the Crown Resorts Group had an understanding that the accounts of this nature were common in the casino industry, that they understood that international patrons and others desired to have accounts for use in gaming in connection with their gaming that allowed them the privacy prescribed, that the Crown Group had an AML CTF program in place. Is it the case that opening a new account, closing one account, was just a part of the ordinary business of the Crown Group?
Oh, as a hypothetical. So what? So what was the actual?
Well, in other
what
words,
was the actual question? Sorry.
Is it possible that no one turned their mind to this because no one was considering the money laundering aspects of the operation of the account?
I mean, I don't really know the answer to that. I mean, all I could suggest is that because the accounts were being dealt with by a Department of Crown, maybe they turned their mind to it. I mean, I didn't really get involved in the accounts. I didn't really pay a lot of attention to it. Maybe I should have, but that's just not something I did in my day-to-day business.
All right. Now, you've not made any mention here of the CBA account that was closed towards the end of 2019, but you remember that being closed.
I was aware later on, I'm not sure when, but round about when the allegations were getting made that of some of these issues.
All right. So can we just walk through that a little bit then? So allegations were made in mid-2019 about Riverbank Investments account, and I say in the media, about the Riverbank Investments account being used to facilitate money laundering, correct?
Yes, they were.
And you were aware of that at the time?
Yes, I was.
After you became aware of it, what did you do as the CEO of Australian Resorts and the CEO of Crown Perth, if anything, to investigate the veracity of those allegations?
Me personally, not a lot. I left that with Mr. Barton and his team. That was something that they were handling.
Did you give any direction or instruction to anyone under you in the management structure to undertake an inquiry and investigation into the reasons or whether there was any substance to those allegations?
I don't recall giving a instruction.
Did you understand what Mr. Barton's team were doing in respect of that? Was there anything being done by his team, to your knowledge, to investigate the veracity of the allegations?
I don't know.
What did you understand that Mr. Barton's team was doing then at that time?
My understanding of Mr. Barton and his team, or the Treasury team, I should say, was they were the team that would open up accounts, be responsible for closing accounts, negotiating with the banks, and running the accounts in general.
Given that you were in a position as the CEO of Australian Resorts, did it not occur to you to, for example, ask Mr. Bossy, who was the COO of the Perth location, what do you know about Riverbank accounts, Mr. Bossy?
No, I didn't do that. It didn't occur to me.
What about Mr. Brown, who ran the cage, asking him what he knew about the operation of the accounts?
No, I didn't speak to Mr. Brown.
Were you not in any way at all concerned about the allegations in the media at that time? There may have been some truth to them.
Yes, that would have been of concern.
Well, given it was of concern to you, are you able to explain why none of the inquiries the kind of just been through were taken by you?
The only explanation I can give is that was something that was handled by others. Not us. That's just how I dealt with that one.
So is it your evidence that you didn't think it necessary because it was, if you like, in the hands of Mr. Barton?
My evidence is that it was in the hands of others and they were dealing with it in an adequate manner, or hopefully an adequate manner.
Were there any discussions then from an operational perspective? Well, let me take that back one step. To what extent, at the time of the closure in 2019, was the operation of the Riverbank Investments account considered to be a necessary component of Crown Perth operating the casino?
My understanding of the Riverbank account was always a necessary component of operating.
All right. So upon learning that the account will be closed in sometime in 2019, were you not then interested in determining if you could continue to operate in the same way with another bank?
No, I didn't. As I said, I didn't turn my mind to that. I didn't get involved in that.
Did it occur to you that if allegations had been made publicly in the middle of 2019 and the CBA Bank was closing the account, there may have been a connection between those two events?
No, I didn't put that together.
Did you become aware in the course of the Bergen inquiry of the examination of Mr. Preston concerning the Riverbank Investments accounts?
Yes, I did.
And did you become aware or understand as a consequence of that evidence that the statements of the Riverbank Investments account revealed transactions that provided an indication of at least one typology of money laundering?
Yes, I did.
And did you understand it to be a typology referred to as structuring?
My understanding of that was it was smurfing.
Smurfing. Well, whatever term one puts on it, did you understand it to be a process by which a large sum of money is broken up into smaller sums, all of which are below the threshold for reporting to AUSTRAC?
Yes, I did.
And when was the first time you became aware that the Riverbank Investments accounts, upon examination, revealed transactions of that character?
That would have been in the Bergen inquiry.
So do I understand from your answer then that whatever Mr Barton was doing between the middle of 2019 and 2020 to investigate this, no one within Crown in that period had discovered, upon an analysis of the Riverbank Investments account, that there was a number of transactions that, upon a plain reading of the account, reflected the possibility of money laundering?
I wasn't aware of anyone discovering that prior to the Bergen inquiry.
When you became aware of that in the middle of 2020 then, were you not completely incensed that no one had brought it to your attention?
In the middle of 2020, yes, it was definitely a concern. It was something that was highly regrettable and it shouldn't have happened.
What I mean to say is, in a year, with one just had to read the accounts. In a year, no one apparently read them and brought it to your attention. You must have been incensed.
It was very disappointing that that these things occurred.
Well, after Mr Preston had given his evidence and became aware of it, what steps were then taken to carry out an investigation into the reasons for the account being used in that way?
Is this post the Bergen inquiry? Is this 2020?
Yes, 2020.
In 2020, I believe that an external agency was utilised to look at it, try and work out what had occurred. Once again, I wasn't directly involved in that, but that was what I was led to believe.
And who had direct responsibility for that item of work?
I don't specifically recall, but I believe it may have been Mr. Barton's team.
And so Mr Barton, I take it, didn't report to you in this period?
No, Mr. Barton's never reported to me.
All right. Now, can I just, to go back to this question of knowledge of the operation of the account, did you understand when you became aware of the transactions on the Riverbank Investments accounts that throughout the operation of that account, no one in Crown Perth had made a suspicious matter report to AUSTRAC in relation to those transactions?
I wasn't aware about the details around suspicious matters or not.
Did you become aware in the middle of 2020 of the that in the operation of the Riverbank Investments account and the internal Crown Perth software, the Psycho software, members of the cage staff had aggregated the individual transactions and recorded them as a single large transaction in the Psycho software?
Yes, I was made aware of that.
And did you understand, as a consequence of that, that the AML team, when they reviewed their daily review of the Psycho records, were not able to see there had been a number of smaller transactions that made up the larger amount?
Yes, I wasn't made aware of that.
Having become aware of that, did you make any inquiries of Mr Brown as the General Manager of Cage and Count as to how it was that people under his supervision had aggregated the amounts?
Personally, no, I did not make inquiries of Mr. Brown.
Did you give any directions to Mr Preston or anyone else to make such inquiries?
I don't recall giving directions to Mr. Preston. I believe that Mr. Preston went and did that anyway.
Is it your understanding that Mr Preston made inquiries of Mr Brown regarding the operation of the cage?
My understanding was Mr. Preston made inquiries of Mr. Brown in relation to the issue of those transactions.
And what is your understanding of when those inquiries were made?
minus any of those inquiries, they were made after it came to our attention that that structuring or smurfing had occurred.
So to put a time frame, is it the middle of last year?
It could be. I mean, it was after, it was either, I think it was during the Bergen inquiry,
All
shortly
right.
after Mr. Preston had given evidence. I'm not sure what date that was.
I see. So it had to be some time between the middle of 2020 and the end of 2020 when you left, correct?
Yes, that would
Sorry,
be.
just to clarify, if the question is when Mr. Felsted became aware as opposed to when Mr. Preston took his action.
I'm happy with that. I thought that was clear, but yes, that you understand the nature of that objection is that the question is whether you became aware of Mr. Preston's inquiries. At what point in time you became aware of that?
I became aware of Mr. Preston's inquiries when, shortly after he'd given evidence to the Bergen inquiry. Or even, sorry, I think it might have been during the evidence he was given to the Bergen inquiry.
Okay, and was that inquiry, was that information provided to you by Mr. Preston directly?
From recollection, yes.
All right, so to the best of your recollection, did you have a conversation with Mr. Preston?
Yes, my recollection is yes.
And what information did Mr. Preston provide to you during that conversation about the inquiries he'd made of Mr. Brown?
From recollection, Mr. Preston told me that there had been a series of transactions that had occurred on the Riverbank account, and they had been aggregated by the cage, which was against procedure, and he was very upset about it.
And was any investigation or undertaken as to the mechanism or reason why the cage staff had aggregated rather than following the procedure?
Not that I'm aware of. I know that Mr. Preston had conversations with the cage staff, and Mr. Brown in particular. The reason was given. I'm not sure what the reason was given why that occurred.
So is it your evidence you can't recall what explanation was given for the process of aggregation by the cage staff?
I can't recall what a credible explanation was given. I do have a recollection that Mr. Preston could not get a satisfactory answer as to why it occurred.
Okay, so when you say you didn't get a credible explanation, what then was the incredible one you received?
My recollection of this was that the cage could not provide any reason why they had done it.
Would that be a convenient time, Commissioners?
Yes. Phil said we'll come back at 2 p.m.
Thank you.